Welcome to our webinar on the Shareholders' Rights Directive II, brought to you by BNP Paribas Securities Services. This webinar has been prepared for institutional investors. There will be a great deal of information on this webinar, and there is more included in our handbook on this subject, and there's a link to that handbook included in the presentation. We have two presenters. Firstly, we have Teresa Alfonso, who works in our International Operating Center in Lisbon and is one of our most expert product managers on asset servicing. And we're also joined by Jean-Florent Richard, who is expert on regulatory affairs and how they impact institutional investors. Teresa, can I ask you to start the webinar?
Thank you, Alan, for the introduction. So the objective of today's webinar is to provide you with an overview of Shareholders' Rights Directive II. We would like to start this webinar through a review of the key elements that compose this European directive. One of the key aspects in understanding the context of the Shareholders' Rights Directive II is to understand that the European Commission has had an objective of reinforcing corporate governance now for a number of years. In fact, one of the aspects of the Shareholders' Rights Directive II is that this directive, published in 2017, is in fact the second version of the first Shareholders' Rights Directive that was issued in 2007. The European Commission realized that the efforts that were put in place by the first version of the Shareholders' Rights Directive I were in fact short, so they reviewed the directive and published a second version in 2017. The new directive establishes specific requirements that aim overmost to contribute to the long-term sustainability of European companies and to contribute to this enhancement of the efficiency of the chain of intermediaries and the encouragement of the long-term shareholder engagement. The three key elements of SRD II can be addressed looking at engagement, transparency, and oversight. Engagement in Shareholders' Rights Directive II is obtained through the facilitation of the interaction between the companies and the shareholders. The European Commission wants to strengthen the shareholders' rights and to increase the dialogue between the companies and the shareholders, and to accomplish this main and very important objective, they have established specific requirements to attain it. So, in order to facilitate this interaction, companies will have the right to identify shareholders. Intermediaries will need to transmit all information relating to the rights attached to the shareholders' shares, and these shareholders will have facilitation in their ability to exercise the rights of their shares. At the same time, intermediaries will also be obliged to be transparent in the costs that they apply to the services provided to shareholders, with a very key aspect that these costs need to be proportional and non-discriminatory. The two key elements of the Shareholders' Rights Directive II are linked with transparency and oversight. Thanks to the transparency requirement, there will be an increased visibility on what are the engagement policies and strategy investments of institutional investors, asset managers, and proxy advisors. And this is what the European Commission means by enhanced transparency, as the public disclosure of these policies and these strategies will be mandatory. Last but not least, shareholders will be given an oversight right. They will have a say on pay and will have a word to bring on related party transactions, and will also have the right to approve remuneration and related party transactions. Another key aspect of SRD II is to understand the scope and the timeline of this directive. If we have a closer look at slide 9 of our presentation, the first question we need to address is around which companies are in scope of SRD II. The scope is in fact quite extensive because the Shareholders' Rights Directive II applies to companies that have both a registered office in a EEA member state and whose shares are at the same time admitted to trading on a regulated market situated or operating within a member state. A key aspect of understanding the scope of SRD II is that the scope of the application of this directive is not defined by the list of countries where the directive needs to be transposed, but is defined by the security that falls into the SRD II definition. Another important point is that although the Shareholders' Rights Directive refers to equity shares in general, the European Commission gave the liberty to the different member states to enlarge the scope of which securities are impacted by SRD II obligations. And in fact, we have some countries that have enlarged the scope of the financial instruments to include as well funds and also corporate bonds. At this moment, and although we are already very close to September 2020, not all transpositions of the directive have been complete. So we will only have full visibility of the scope of securities when all transpositions are effective. In terms of the shareholders that are impacted by SRD II, SRD II applies to all shareholders wherever they are located, not only to shareholders that reside or are present in Europe. So if you are a shareholder investing in a European company within the scope of SRD II, you will have exactly the same rights as if you were a shareholder residing in Europe. In terms of those rights that shareholders will be entitled to, SRD II establishes, as I have referred to already, to very specific requirements, and all of them are aimed to encourage the long-term shareholder engagement. And these requirements are the identification of shareholders, the transmission of information, the facilitation of the exercise of shareholders' rights, the non-discrimination of costs, and as well the transparency of institutional investors, asset managers, and proxy advisors, and as well the remuneration of directors and related party transactions. Depending on where you are located in the custody chain, the impact of these requirements will be different. In the case of BNP Paribas Securities Services, as a custodian and as an intermediary, our main impact is around the identification of shareholders, the transmission and the facilitation of the exercise of shareholders' rights, and the transparency of costs. But regardless of where you are in the chain, if you are in scope of SRD II, you will need to comply with these requirements, whether you are an intermediary, an institutional investor, an asset manager, etc. Wherever you are, so SRD II has an extraterritorial impact. If you are servicing an issuer or a shareholder, you will need to comply with the requirements of the directive. Another important aspect of SRD II is to understand that SRD II is not only a directive, it comes paired with an implementing regulation. So this implementing regulation was published by the European Commission with the objective of limiting the possible divergences that could arise from the different transpositions made by the different countries. So in terms of the implementing regulation, it aims to define the types, formats, contents of deadlines of the different messages that will need to be exchanged especially by the intermediaries and the issuers, to facilitate the transmission and the facilitation of shareholders' rights. Just looking very quickly at the timeline, the Shareholders' Rights Directive II entered into force in 2017, and the European Commission published the implementing regulation, also known as Level 2 Technical Standards, in the 3rd of September of 2018. And this is when the clock started ticking for the different participants to start preparing for the implementation of the shareholder identification, transmission of information, and facilitation of voting rights. So in the 3rd of September of 2020, all the requirements and features described in the implementing regulation of SRD II will need to enter into force. Another particular constraint of SRD II is that EEA countries had until the 10th of June of 2019 to transpose the Shareholders' Rights Directive II into the national laws. To date, and we are in June 2020, not all countries have successfully completed the transposition of the Shareholders' Rights Directive II. This aspect is important to highlight because some of the aspects of the directive have a direct implication on how the implementing regulation will be applied. In slide 10, we have a closer look of Chapter IA that defines the requirements that will need to be complied relating to identification of shareholders, transmission of information, facilitation of the exercise of shareholders' rights, and transparency and non-discrimination of costs. We provide here an overview of what is the impact of these requirements on intermediaries, because as they provide these services, they are one of the main participants impacted in their adaptation to Shareholders' Rights Directive II. So as from September 2020, issuers will have the right to request shareholder identification on the shareholders investing in their companies, and it will be up to the intermediaries receiving this request from the different CSDs in the different countries who constitute the first intermediary, and to pass on this request to the next intermediary in the chain, or respond back directly to the issuer where that intermediary already has the information on the beneficial owner of those shares. In terms of transmission of information, issuers will be required to issue standardized information on the different corporate events affecting their companies, and intermediaries will have to, following the chain, transmit that information to the next intermediary without delay. And without delay means in a process compliant with the record date or the issuer deadline established by the company. In terms of the facilitation of the exercise of shareholders' rights, the two main aspects that are a novelty brought by SRD II is not only that intermediaries will be obliged to always facilitate the exercise of their voting right, but also has to do with voting confirmations. So issuers, as from September 2020, will need to issue a voting receipt, which means that they have received the confirmation that a vote has been well received and has been cast. And once the general meeting has taken place, they will need to issue a confirmation that that particular vote has been recorded and taken into account for the purpose of that general meeting. In terms of Article 3B, that relates to the non-discrimination, proportionality, and transparency of costs, intermediaries will need to publicly disclose the fees that they apply to their services. And those fees will need to be proportional to the costs of the services provided and need to be non-discriminatory, meaning that in, for instance, a scenario of cross-border voting, intermediaries cannot charge a shareholder for an extra fee just based on the fact that that shareholder is not located in Europe. So the fees will always need to be proportional, and if any extra fees are incurred, intermediaries will need to publicly disclose it and justify it. So now we have provided you with an overview of what are the key elements, what is the scope, what are the requirements of SRD II, requirements focused on Chapter 1A, the ones that are directly linked with the implementing regulation. And we would like now to explain to you how this will translate into a concrete impact. So what are the key impacts for you as a client relating to all these requirements? In order to address them all, we launched a project plan to ensure that we would be compliant both with the directive and the implementing regulation by the live date of the 3rd of September 2020, and we have been adapting progressively our processes and our service offer to integrate those impacts and address them. I can also refer that BNP Paribas has been a key member of all the Shareholders' Rights Directive II task forces that were created by the industry to address the impacts and the constraints of the directive and the implementing regulation. So in terms of identification of shareholders, we will manage this requirement through an in-house solution that we have been developing, and through which our systems and internal processes will be capable to comply with the provision to identify a shareholder. In terms of impacts, there will be no impact for beneficial owners. And why is that? Because when we receive a shareholder identification request issued by a company or an issuer and sent to a CSD or another entity appointed by the issuer, we can immediately provide the response back on the details of that particular beneficial owner. So there will be no impact for you because BNP Paribas will be capable of responding back to the issuer directly. And this is in line not only with SRD II requirements, but as well with the industry standards that have been created for the management of the shareholder identification process. Another aspect of the identification of shareholders requirements is that you are entitled to obtain visibility of the information that has been provided by BNP on your behalf. And as such, we have created a shareholder identification response screen in our internet portal, NeoLink, where you will be able, if you subscribe to it, to retrieve all issuers' requests and responses that we have provided on your behalf. This is a right you have in the scope of SRD II, and as such, we will make this information available to you. In terms of transmission of information, it is important to understand that this requirement applies to corporate actions, income, and general meetings, corporate events. So any rights pertaining to a security in scope of SRD II are affected by the transmission of information. So as an intermediary, we will provide you with the notification of all corporate events, in line with the requirements of SRD II and the tables of the implementing regulation. We can highlight that for corporate actions and income, which are the areas we can say with the least impact, both the issuer and our response deadlines will be, as from September 2020, expressed in Coordinated Universal Time, UTC, which is a requirement imposed by SRD II. So you will continue receiving your corporate events through the usual channel, and if you are a Swift user, 1502, but both the issuer and our response deadlines will be expressed in UTC time. For general meetings where we operate in partnership with our long-term provider, Broadridge, we have engaged with Broadridge to ensure that the offer is compliant with SRD II, and Broadridge will comply with the same-day, intraday transmission requirements, and as well with the processing of general meetings, voting instructions at the beneficial owner level. At your end, and similarly to the identification of shareholders, this process will not have an impact. You will continue communicating with Broadridge through your usual channel, and placing your voting instructions as per the usual way. When Broadridge communicates your voting instructions to the Paribas network of sub-custodians, your instructions will be enriched with the beneficial owner data we have stored in our systems. In terms of the facilitation of shareholders' rights, as I was already explaining, there's a new requirement to process the votes for final beneficial owner, and this will enable you to receive then accurate vote confirmations, both for the voting receipts and the confirmation that the vote has been executed and counted. An important aspect to highlight is that as an intermediary, we are obliged to transmit to you this information and to facilitate your exercise of shareholders' rights. So if to this date you are not yet subscribed to our general meetings service, we would recommend for you to contact your client representative who can provide you with all required information so you can start receiving all the information I have described as from September 2020. So we have looked at the key client impacts coming from SRD II and linked with the impact on intermediaries. At the end, there will be a Q&A to address any specific questions you may have.
Thank you, Teresa, for your presentation. As already explained by you, SRD II aims to encourage long-term shareholder engagement in listed companies and to improve transparency on shareholder engagement. Talking about greater transparency on shareholder engagement activities, asset management mandates, and investment strategies, is talking about the transparency requirements of SRD II. It's also talking about stewardships, about how to encourage the institutional investor community to engage more actively in the stewardship of the company in which they invest. SRD II established a new regulatory baseline on stewardship and stewardship activities for certain asset managers and institutional investors. To achieve this, under Chapter 1B of the SRD II, the European legislator has specifically imposed additional obligations on certain asset managers and certain institutional investors. But which institutional investors and asset managers are we talking about under SRD II? By institutional investors, is meant life insurance companies and life reinsurance companies, together with institutions for occupational retirement provisions, so-called YOPs. By asset managers, we commonly refer to MiFID portfolio managers, alternative investment fund managers, and UCITS management companies. All of them invest in shares traded on regulated markets. Under SRD II, asset managers, as I said before, and institutional investors investing in listed companies are subjected to additional regulatory requirements from 10 of June 2019. What are these requirements? We may say that they are threefold. First, SRD II requires all institutional investors and asset managers to develop and publicly disclose an engagement policy. Second, SRD II requires institutional investors to publicly disclose how their equity investment strategy is consistent with the profile and duration of their liabilities, with a particular focus on long-term liabilities. Institutional investors are also required to disclose detailed information where an asset manager invests on their behalf. Third, asset managers are required to annually disclose to institutional investors how their investment strategy contributes to the medium long-term performance of the assets of the investor or the investment funds. Now, let's move to slide 16. SRD II requires institutional investors and asset managers to develop and publicly disclose an engagement policy, as I said before. This engagement policy describes how they integrate shareholder engagement into their investment strategy. This may cover topics such as how the firm monitors and conducts dialogues with invested companies, or exercise voting rights, or cooperates with other shareholders and manage conflict of interest, for instance. Institutional investors and asset managers also have to annually disclose how they have implemented their engagement policy, including how they have cast votes in general meetings of invested companies. Firms must give explanations of the most significant votes and may exclude insignificant votes from the disclosures. SRD II allows firms to choose not to comply with one or more of these requirements, but in that case, they must publicly disclose a clear and reasoned explanation for that decision. It is important to note that there may be difficulties for firms using delegation arrangements to non-EEA affiliates who are not subject to SRD II or firms outside their group. Institutional investors and asset managers may have to think carefully about which activities are in scope of SRD II disclosures in relation to these arrangements. Institutional investors and asset managers will need to consider how they can track their shareholder engagement for the purposes of their annual disclosure. Similarly, institutional investors are required to reference information published by asset managers who implement their engagement policy, which may require some coordination. Compliance may also be quite difficult for asset managers who only invest infrequently in listed shares, for instance, private equity firms, as establishing the necessary tracking mechanism may be quite onerous. Let's move on to the next slide, number 17. SRD II requires investors and asset managers to publicly disclose how their equity investment strategy is consistent with the profile and duration of the liabilities, with a particular attention on long-term liabilities. Institutional investors are also required to disclose detailed information where an asset manager invests on their behalf, either, like I said before, on a discretionary client-by-client basis or through an investment fund, or give a clear and reasoned explanation as to why they have omitted any elements. Required in details include incentivization of the asset manager to align with liabilities, incentivization of the asset manager to make long-term decisions and engage with invested companies, how performance and remuneration of the asset manager is in line with the liabilities of the investor, of the institutional investor, particularly long-term liabilities. Next, monitoring of portfolio turnover costs, and the duration of the arrangement between the investor and the asset manager. Practically, the implementation of these disclosures may be difficult where an institutional investor uses a number of asset managers or invest in multiple investment funds. Here we see there is a challenge in terms of sourcing the information required for disclosures. In addition, where an institutional investor invests in an investment fund which is not a bespoke arrangement for that investor, some of the disclosures may be less meaningful, and in any event, the investor may not be in possession of all the relevant information necessary to make the disclosures. They may also not be able to impose their own standards on the asset manager if they are just one of many clients. Furthermore, last and not least, for clients, the question can also be how the requirements can be satisfied without disclosing some commercially sensitive information. Let's move on to the next slide, number 18. Asset managers are required to annually disclose to their clients, to institutional investors, how their investment strategy contributes to the medium to long-term performance of the assets of the institutional investor or of the investment fund. This is composed of a certain number of elements. First, key material medium to long-term risks associated with the investments. Second, portfolio composition, turnover and turnover costs. Third, use of proxy advisors for the purpose of engagement activities and their policy on securities lending, and how it is applied to fulfill its engagement activities, if applicable, particularly at the time of the general meeting of the invested companies. Fourth, how they make investment decisions based on evaluation of medium to long-term performance of the invested company, including from a non-financial performance perspective, and on whether, and if so, which conflicts of interest have been qualified in connection with engagement activities and how the asset managers have dealt with these conflicts of interest. Here, one of the main questions which may be raised is to know whether disclosure only has to be given to institutional investors with whom an asset manager has an arrangement, or whether disclosure has to be given to all investors of the same investment funds, for instance, more broadly. To me, according to the Directive, to SRD II, disclosure only has to be given to institutional investors who have an arrangement with an asset manager or asset managers. The definition of arrangement may raise questions also. For instance, is a dedicated sub-fund or a dedicated fund an arrangement? Very likely. What about a dedicated share class? It may be less likely. Anyway, in other words, there is a question as to whether asset managers have to identify the relevant institutional investors within their client base, or only make such disclosures to them. Now, after this quick overview of these new requirements for institutional investors and asset managers, a few words on our BP2S service offer. You remember that asset managers who have an arrangement with an institutional investor, meaning a life insurance company, a reinsurance life company, or a YORP, have to report on an annual basis a certain number of data, including, among others, portfolio composition, portfolio turnover, and portfolio turnover costs. BP2S has developed an offer to specifically support our clients in relation to the portfolio turnover ratio, and portfolio turnover cost and portfolio turnover ratio. I won't go into the details of this offer, but I warmly invite you to liaise with your usual relationship manager, with in mind that this offer will be fully deployed as from September 2020. I remain at your disposal for any questions you may have. Thank you.
Thank you, Teresa and Jean-Florent. So if you would like to ask a question, please enter your question into the chat box on your screen. And now I'm going to turn it back over to Alan.
Thanks, Tiffany. Well, we're joined now as well by Mariangela Fumagalli. And Mariangela is responsible for making all the custody products at BNP Paribas Securities Services compliant with SRD II. So she's a very busy person. Mariangela, thank you for joining us. Whilst we wait for questions to come in, could I just ask you a couple of things that I'm sure many people are wondering about? We hear a lot of talk in the market about the possibility of a delay to this regulation, particularly since COVID-19. And I was wondering what your views are on that. Do you think it's likely there might be a delay?
At the moment, it's not very likely at all, Alan, unfortunately. There's been a letter prepared by various industry associations, including custodians, CSDs, issuers, that were sent back in April to the European Commission in order to raise awareness of the lack of readiness of the industry vis-a-vis the implementation of SRD II. This is not only linked to COVID, but overall there is a series of issues. The fact that several member states haven't yet finalized the transposition of the directive is a serious legal constraint. There is also lack of readiness from a technical point of view from various CSDs. There is been a delay in the readiness of the standards intended as the messaging that needs to be exchanged across the industry to achieve a machine-readable STP process of all SRD II mandatory information. Despite all these reasons, the European Commission reverted back saying that the live date will be maintained as of the 3rd of September. And the industry is now trying to put forward some more arguments for asking for a delay. However, I don't see this as being successful because we are now a little bit too late to announce a delay. But we can try at least to ask for the Commission to provide a reduction, I would say, of the consequences or in case there is no compliance, because at the moment a lot of the member states will not be compliant because the CSD is not ready and won't be ready by the 3rd of September.
Thank you. Now, I guess the fact that a lot of people are asking about delays suggests that not everybody is completely ready for this. How prepared is the industry for this?
I think the industry is trying their best to be ready for the 3rd of September, considering that at the same time, both intermediaries and CSDs are also trying to be ready for CSDR, which is another big regulatory text that was meant to go live at the same time. But overall, we have an underlying problem, which is the lack of transposition. So it's very difficult to be ready for something that's not yet been implemented into the national law of the country in which you are trying to get ready. I think the more we get closer to the live date, the more we will see announcements, especially from CSDs saying they won't be ready. And so I think that the majority of custodians at the moment are trying to understand what's the best way to still trying to shield their clients from this lack of readiness of the CSDs and still providing a service which is as much as possible compliant, although it won't be fully compliant as of the 3rd of September. It will take a few months after live days. Based on information we have so far, the majority of the markets will probably be ready by Q1 next year in preparation for the general meeting season next year.
Okay, we have some live questions coming in. Actually, maybe I could ask you this question, Mariangela. It's quite a tricky one, and it is something I've often wondered about myself. And the question is, what will happen if providers located abroad don't comply with SRD II? The questioner is thinking particularly where local legislation may be in conflict with the requirements of SRD II.
So if we look at the text, SRD II clearly says that all intermediaries need to comply with SRD II, even if they are located outside the European Union. And in some transposition laws, there are penalties that will be applied to intermediaries that do not comply with SRD II. Concretely, how the national competent authorities of the relevant country will be able to apply such penalties on an intermediary that may be resident outside the European Union is still to be seen. Also, our understanding from various discussions in the industry is that although SRD II, for example, provides a clause that allows to bypass some of the GDPR rules for the disclosure of shareholder, the same doesn't apply outside Europe. So if you are resident in a jurisdiction outside Europe which has a strict bank security, then there will be a conflict of law. And the understanding that is being shared in various industry associations is that the local law will probably prevail, and so no disclosure will take place. But this is still a subject which is under discussion in various associations because things are not as black and white as probably everyone will want, and it's subject to various interpretation of different legal counsel and compliance officers.
Okay, thank you for that. Teresa, maybe I could put this next question.
Just one point. Within the European Union, if we are talking about bank secrecy laws that may apply within the European jurisdiction area, then the SRD II provisions supersede. So if we talk about Luxembourg, the SRD II provisions and the requirement to disclose under SRD II supersede any Luxembourg bank security. The same will not apply, for example, to Switzerland or Singapore or US. So within the European Union, it's been agreed that SRD II supersede any local bank secrecy, but not outside the European Union. Sorry, Alan, I just noticed the question you were referring to.
That's helpful. Maybe I could ask Teresa to address this next question, and it's very specific. It's about a US asset manager using BNP Paribas for global custody. And if this asset manager, as many do, outsources proxy voting to Broadridge, the question is, what would they do through Broadridge and what would they do through BNP Paribas? So I guess what information and how would they engage with Broadridge and how would they engage with BNP Paribas? Could you answer that, Teresa?
In terms of a buy-side client that is benefiting from our global custody offer, the interaction with Broadridge in what respects general meetings in scope of SRD II remains the same. So the client will continue to place its voting instruction through proxy edge as it happens today, and when the instruction is sent by Broadridge to the sub-custodian within the BNP Paribas network, that instruction will be enriched with the beneficial owner data required by the Shareholders' Rights Directive II, because instructions will need to carry the details of the beneficial owner. In terms of the provision of the general meeting notification, we have also worked with Broadridge so that Broadridge is capable to meet the intraday requirement for the provision of the meeting notice. So Broadridge will provide a first general meeting notice and then a second meeting notice with the complete information. In terms, and this is the process for general meetings. In terms of the shareholder identification process, the process will not be handled through Broadridge. We will handle the process in-house. So when we receive a shareholder identification request, we will send the response back directly to the recipient appointed by the issuer. So there will be no impact on the beneficial owner side. And if the client wishes, they can access the information we have provided on their behalf through our Neo Impact portal.
Thank you very much. Now, there's another question here about the countries which haven't finished transposition yet. Without listing them all, the question is which countries haven't finished the transposition yet? And I guess a supplementary question to that would be is what impact is that having?
So I don't remember at the top of my head all the list of the clients that haven't transposed. France hasn't finished the transposition. They've started, but it's not finished. Portugal, the same. The UK hasn't transposed yet. And then there's a long other list ongoing. I can, we can make the list available if the person asking a question contacted the relationship manager. We can share the full list. Apologies, I don't remember it all, but it's quite a long list, unfortunately.
It's quite a long list.
So yes, because some countries have started the transposition, but then with the COVID, and in fact the Parliament could not convene, the transposition hasn't progressed as much as it should have, or it would have without the current situation. So there is a bit of delay on approvals within the Parliament in various European countries. So we can make the list available, but ultimately what is going to happen is that we will still have level 2 that will automatically enter into force on the 3rd of September, but we won't have a level 1 to fall back on. So ultimately, there will be a bit of an issue between the the provisions in level 1 and level 2. So effectively what's going to happen is that, especially around shareholder identification, in some countries, you will still have a coexistence between the existing shareholder identification process and the new one that will come in SRD II, until this double level, the two laws are going to be superseded, and the existing law will be replaced by SRD II. But again, we have to see country by country how many are going to be able to push through the approval in the summer, because there is a lot of emphasis on various member states to try to get approval in July and August to make sure that they're compliant on the 3rd of September. And the European Commission, we are aware, has put a lot of pressure on the member states to ensure that such transposition is taking place. So at the moment, we are all monitoring the list and making sure that more and more countries are taken off the list.
Okay, thank you. Jean-Florent, can I ask you to address this question? It says, is it fair to assume that this regulation also applies to US 40 Act mutual fund managers? So it's a question really about who does this regulation apply to?
It's an excellent question. As per the definition of asset managers under SRD II, it only refers to asset managers which are licensed in Europe based on a local notification with a supervisory authority. Difficult to answer straight away, but I would say that asset managers who are not European based are out of scope in terms of transparency requirements. I think the question is related to these aspects only. Yeah?
Okay, thank you. Teresa, there's one here maybe I could ask you. It basically says, what about corporate actions? What does SRD to harmonize and make better corporate actions?
In terms of corporate actions, SRD II establishes as well requirements for the transmission of corporate events other than general meetings. So in what relates the transmission of a corporate event announcement, there is a specific requirements that are outlined in the implementing regulation, namely on Table 8. So we have adapted our 1502 MT564 message to incorporate those requirements. We were already compliant with most of them. The one we really like to highlight is the future transmission of the response deadlines and the issuer deadline, quoting the universal coordinated time, which is an important improvement that eliminates the existing scenario today with discrepancies between the timelines provided. So we will have an important improvement in what relates to that. And there are also requirements relating to the deadlines that are established for the transmission of the information, where we will transmit the notifications within the same business day they are received, or until 4 p.m. the next business day, until 10 a.m., the next business day, if they are received after 4 p.m. In any case, we are taking the necessary steps so that although we want to maintain the compliance with the deadlines established by SRD II, we also want to ensure that the quality of the announcements is not jeopardized by these time constraints. Although in the majority of cases today, we are already compliant with this requirement imposed by SRD II.
Thank you. So we're coming to the end of our webinar. So it really just remains for me to mention that our next webinar will be on CSDR, and that will be in September. This webinar, and indeed an earlier one that we did on the regulatory impact of COVID-19, they are available on our website from July. And on our website, you will also find a handbook, you will find podcasts on SRD II and lots of other subjects as well. So please do visit it. So it's really for me to thank Teresa, to thank Jean-Florent, and to thank Marie-Angela for participating and giving their time to this webinar. And most of all, to thank Tiffany from our marketing department, because without her, none of this would have happened. And thank you very much for joining us. So this has been hopefully interesting. If you have further questions, please do not hesitate to contact your BNP Paribas Securities Services Relationship Manager. And thank you for joining us today.